Watamuli, everyone, and welcome to Bebeguyumba campus of JCU. Welcome back to many of our Indigenous Research Support Network members, and welcome to those of you outside of the network who we're very grateful to be able to open to a wider group and audience today to have with us Professor Gabrielle Appleby. I'm not going to say too much about Prof because she's going to introduce herself and share a bit about her background and what she's here to talk with us about today. But I will say that Prof is a constitutional law professor at the University of New South Wales, and that you have worked alongside many of the Uluru Dialogue leaders over the course of years dating back to the Referendum Council's work. And she's here to give us some insight into those processes and the specific work that you've done around the amendment language drafting. So thank you for being with us. And of course, I said Watamuli, but of course I want to acknowledge country. So we're here on Bindal country, and we have close to us Wulgurukaba country, and I want to acknowledge ancestors and elders past and present for their continued care of this country, for the way that they hold law and keep law alive in this place, and for their ongoing political claims on behalf of all Aboriginal people and Torres Strait Islanders in this country. So, you know, my deepest respects to them and acknowledgement of country in the context of the significance of this moment.
Great.
Over to you.
Thank you very much, Prof. Sana. I'm going to go up to lectern for the purposes of recording, and it will be a relatively formal start for the purposes of recording, but I really am looking forward to the informality of the discussion. I want to start also by acknowledging country, visiting country here, and paying my respects to elders past and present. I acknowledge the sovereignty of the traditional owners over these beautiful lands and the beautiful waters. I haven't been to this country before. I'm travelling here from the country of the Bidjigal and the Gadigal people of the Eora Nation in Sydney, where I live and work. I also want to thank Associate Professor Sana Carter and Dr. Janine Gertz from UNSW and the Centre here for arranging this time to come and talk to you. Today's sort of seminar talk is really, I want to do three things. I'm a constitutional lawyer, so I want to talk to you about the constitutional amendment and the words, the choices that were involved in those words and the language of those words and the history of those words. And then I'm going to talk a little bit about the history that sits behind those words, because history is very important to understanding constitutional interpretation and constitutional language. And then I'm just going to conclude with some reflections in relation to the nature of the proposal for the First Nations voice, and talk about how it's a really sophisticated and nuanced proposal that is both modest in terms of constitutional traditions, but also transformative in terms of what it holds for the future. So I'm a non-Indigenous constitutional lawyer. I've practiced now for over 2 decades, particularly in government integrity and parliamentary law and procedure. So one of my roles is as a constitutional advisor to the clerk of the House of Representatives in the Commonwealth Parliament, advising them on tricky constitutional issues that occur before the Parliament. So I have, and in the past, I've worked for government at Queensland Crown Solicitor and Victorian Government Solicitor's Office and their constitutional teams. So I have quite a deep experience in public law and constitutional law. It's only been since 2016, however, that I've come into the space of constitutional recognition for First Nations people. I was invited into that space by Professor Megan Davis, who's the director of the Indigenous Law Centre at UNSW Law and Justice. And she invited me at the point of time where the regional dialogues and then which led to the First Nations Constitutional Convention were just getting started. She invited me to be involved in the trial dialogue in Melbourne in 2016 because I needed more expertise to be on hand, to be on tap, to inform the discussions of the delegates at those dialogues. They wanted people to be there to be briefing the working group leaders and the chairs to make sure they felt comfortable talking about the issues, but also then just to have the chats with people in the dialogues themselves, the some of the best chats I had were over a cup of tea in the break where people could ask questions and that type of thing. So providing that support to those delegates who then had to make those decisions that led to the Uluru Statement was how I got involved. Since then, I've continued to work with Professor Davis alongside others, such as Arnie Pat Anderson, to try to deliver those reforms that were called for in the Uluru Statement, starting, of course, with the first in that sequencing, the First Nations voice. Okay, so as you all know, we stand on the precipice of a really historical constitutional moment. The voice referendum approaches us on the 14th of October, ever closer, and the Australian people are going to be asked whether or not they will exercise their constitutional responsibility to amend the Constitution to recognise the place of Aboriginal and Torres Strait Islander people as the first peoples of this land we now call Australia, and to do this through a structural reform, the creation of a new constitutional platform, a new body to enhance political participation for Aboriginal and Torres Strait Islander people. The proposed wording to achieve that is relatively brief. Now, I'm a lawyer, and so I think words are very important. So I'm going to put the words on the screen of the constitutional amendment. Some of you will be very familiar with these words, but they are really important to focus on. I'm going to go through the provision. I'm going to step through the provision and explain some of the language choices behind them. So first of all, Chapter 9, Recognition of Aboriginal and Torres Strait Islander Peoples. It's really important to pause and reflect. This is going to be, if passed, a new chapter in our Constitution that comes at the end of the existing 8 chapters of the Constitution. This was a really important structural drafting decision in terms of the amendment. It was decided not to include it within the existing institutions of government. There's a chapter on the Parliament, there's a chapter on the Executive, there's a chapter on the Judiciary. There's important structural implications that come from that structure, and there was a concern that they didn't want to interfere with those structural implications. There was no other logical place to put this provision. There's chapters about trade and commerce, there's chapters about states and new states. There's a chapter called Miscellaneous, which seems pretty the wrong place for this. And there's a chapter on alteration. So there's no other chapter where this provision would readily go. So yes, they needed a new chapter, but it was also important narrative recognition to place this chapter last in the Constitution. It's a recognition that this step has come after struggles, decades, centuries of struggles. But it's also, so it's part of this sort of constitutional truth-telling, but then it's also part of, whilst it's come after, it's offering a new beginning for this Constitution as well. So it's Chapter 9, it's at the end, and that there is a lot of thinking that goes behind that decision. Section 129, Aboriginal and Torres Strait Islander voice, that's the heading of the new section. Now, I do want to just note the name of the body. The Uluru Statement from the Heart calls for a First Nations voice, and the drafting adopts the language of Aboriginal and Torres Strait Islander voice. This again is a narrative choice, okay? The choice, as I understand it, rests on 2 bases. The first is that there was concern expressed by those advising the government that there might not necessarily be recognition of the language of First Nations in the Australian context across the Australian population. And there's a pragmatic concern that this needs to get through a referendum and people need to recognise what this amendment is going to be about. So the adoption of the language of Aboriginal and Torres Strait Islander people, which was more frequently adopted, particularly in the government setting in Australia. Secondly, there were also concerns among a minority, I will say a minority, but there were concerns amongst a minority that the language of First Nations might imply notions of sovereignty, and there may therefore be a confusion in relation to sovereignty in the constitutional system, which would be a particular issue in relation to a number of constitutional conservatives who were otherwise supportive of the provision. So there's a pragmatic compromise there as well. Okay, so that first sentence then, in recognition of Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. This is the first purpose of the amendment, an explicit statement of recognition. Interestingly, the statement of recognition, the language of First People, is consistent with the statement of recognition that was attempted in the 1999 preamble, of course, which was proposed by John Howard. So there is a consistency there with a previous attempt, a Conservative government attempt at recognition. So there's a similarity of language. Then we come to our first substantive section of section 129, subsection 1. There shall be a body to be called the Aboriginal and Torres Strait Islander voice. This is the establishment. This cements the existence of the body as a constitutional body. The fact that it's referred to as a body indicates it's a separate legal entity, okay? And also clarifies this language of voice, which might not necessarily be readily understood within the broader public. It does have its minimum parameters set, Aboriginal and Torres Strait Islander voice. Most constitution lawyers would agree that the High Court may imply minimum characteristics to this body. The government can't create a body that if you looked at it, you couldn't say, this isn't an Aboriginal and Torres Strait Islander voice. They would be pretty minimum, but they may relate, for example, to the indigeneity of members of the body. There has been some concern that whilst we talk about this as about the establishing, the constitutional establishment, the cementing of the existence of the body, that there are other provisions in the Constitution that use the same language. Section 101, there shall be an interstate commission. And so in fact, this isn't really protecting or guaranteeing the existence of the body. Those analogies are deeply flawed. They may look on the first glance to have some level of substance to them, but when you look at the analogy, Section 101, the Interstate Commission was a body that was established to basically resolve interstate trade and commerce disputes, which is a big issue in the 1890s. The High Court hated it from its establishment. It stripped it of its powers, and so it had no real function. It had no constituency. It wasn't representative. And so once it was disestablished, no one ever challenged its disestablishment. Okay, so the fact that it no longer exists is part of its constitutional function, but also the fact that it didn't really serve a purpose or a constituency. This is very different from the voice. Okay, the voice has been carefully crafted to have a useful constitutional mandate that complements the existing mandates of the Parliament, the Court, and the Executive, and a very clear constituency of Aboriginal and Torres Strait Islander people to demand its continued existence. Okay, so it is right to say there shall be a body to be called the Aboriginal and Torres Strait Islander voice is about constitutional establishment and cementing the existence of the body. So subsection 2, we now turn to the constitutionally guaranteed minimum function of the voice. So the Aboriginal and Torres Strait Islander voice may make representations to the Parliament and the executive government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander people. This is the section that has given rise to the most debate in legal circles, in political circles, and into the public arena. It's been the subject of debate within the government during the drafting process and, of course, the parliamentary committee process. There's sort of two issues that I want to focus on in relation to this subsection. The first is the scope of the voice's engagement with Parliament and the Executive. So in the provision, it talks about on matters relating to Aboriginal and Torres Strait Islander peoples, okay? Ultimately, the question of what is the scope is resolved by creating a legal boundary. So the voice will not be able to speak on matters that don't relate to Aboriginal and Torres Strait Islander people, that don't have what we call a sufficient connection, a too insubstantial or tenuous connection to Aboriginal and Torres Strait Islander people. So there's a legal limit, but it's very broad. Okay, so I don't have to tell this room that so many matters relating to health, education, obviously land, but even, dest I say it, matters relating to defence will relate to Aboriginal and Torres Strait Islander people as well. So it is intentionally broad, okay? So that within this mandate, the voice itself is going to have to determine its priorities. And that's an element of self-determination there in that subsection. It's going to determine its priorities. It's going to be informed by politics. It's going to be informed by pragmatism. The voice is going to be accountable back to Aboriginal and Torres Strait Islander people. It'll be representative of them and accountable back to them. So, of course, it is going to have to work on matters that are priorities for those people. Okay, so the political accountability of the voice back to Aboriginal and Torres Strait Islander people is part of how we know it's going to direct its attention to the right matters. And secondly, the pragmatic reality, the voice isn't going to have unlimited funding. Okay, so it can't speak on everything. Don't believe what the politicians are saying. It's going to have a limited set of resources. It's going to be politically accountable back to its constituency. And so there is going to be a definite focus on the matters that are of most concern to Aboriginal and Torres Strait Islander people. And it's likely to have the most power with respect to. Okay, if it's going to spend all of its time trying to change defence procurement policy because it may have some small link back to Aboriginal and Torres Strait Islander people, there's lots of other interest groups trying to get into those decisions. Whereas if it's really focusing on cultural heritage protection, delivery of services into regional and remote communities, that's where the government's likely to listen. Okay. So the second point about this subsection, there's also been raised questions in relation to whether the voice will have discretion as to whether to make its representations to government or parliament, and whether or not it can be compelled to make representations. So the language of may make representations was really carefully selected, okay? And what it means is that the voice can't be compelled to speak to government and parliament. The government and parliament can ask it for its advice, for its views, but if it doesn't want to spend its money and resources on that particular issue, it can't be compelled to do so. That's a really important part of using its resources well. Equally important, however, is that this is a constitutionally guaranteed function and the parliament won't be able to stop the voice making representations when it decides to do so. If you've read the No pamphlet, you will have seen a quote from Professor Davis and myself, which talks about the idea that the parliament won't be able to shut the voice up. Yes, exactly. That's the point, and that's a good thing. This is the whole point of constitutionally guaranteeing the minimum functions in subsection 2. They can't be taken away. Okay, there has been quite a lot of controversy in relation to the effect of the voice's representations, with a lot of this controversy around constitutional risks surrounding what is the effect on the voice's representations, particularly to the executive government, and will the executive government have to take those representations into account, or it might lead to an invalidity of the decision. Not necessarily that it has to follow them, but it has to take them into account, it has to consider them. This even raised an argument that was put by then Shadow Attorney General Julian Leeser that perhaps the language of the executive government should be taken out entirely from subsection 2 as a drafting decision. This was firmly rejected, uniformly rejected by the Aboriginal and Torres Strait Islander leadership that was advising the government. And I think Senator Patrick Dodson has written really well about the importance of including the executive in subsection 2 in his recent monthly essay, when he talks about the sheer volume and importance of decisions the executive government makes with respect to Aboriginal and Torres Strait Islander people. This function has to be guaranteed. It can't be left to the discretion of the parliament. Now, ultimately, lots of lawyers have looked at this subsection, former High Court judges, solicitors general, lots of the leading constitutional practitioners, and the vast majority, not all lawyers, because lawyers don't always agree, we're not a homogenous group, but the vast majority of lawyers, and dare I say it, those lawyers with relevant experience and expertise agree that this provision is unlikely to be interpreted so as to require the executive to take into account the views of the voice. Yes, the voice is going to be able to speak to the executive, but the voice is not going to have to give notice. Sorry, the executive is not going to have to give notice to the voice, to consult with the voice, to take into account the voice's representations or comply with those representations. Okay, all this guarantees is the right to speak. Very important, very powerful, but it doesn't place any obligations on the executive. The vast majority of legal opinion agrees that the effect of the voice's representations will be determined by the parliament. So we come to subsection 3, a really important subsection. It says the Parliament shall, subject to the Constitution, have power to make laws with respect to matters relating to the Aboriginal and Torres Strait Islander voice, including its composition, functions, powers and procedures. This is the bit about detail, right? So when we hear the debates around detail, who is going to be in charge of the detail of the voice? Subsection 3 tells us it is the Parliament, the democratically elected legislature that conducts its work in public, will be in charge of determining the detail. Nothing is being secretly smuggled in here. We're giving that process to the Parliament. Now, this is very consistent with constitutional practice, not just in Australia, but internationally, okay? The Constitution itself is left enshrining high-level principles, the existence of the body, subsection 1, its primary function, subsection 2, and then the detail is left to Parliament or sort of contingent. There are many good reasons for this practice. One of them is to avoid justiciability, okay? So the High Court has the final say, making sure the body exists, making sure its core functions continue to exist, but otherwise it's for Parliament to determine how the voice is going to operate, as well as preserving an important level of flexibility in the voice's design. All right. So we can have lessons learnt from experience in the decades to come. Constitutions, by their nature, are intended to endure. You don't want to put too much detail in them because it's very, very difficult to change them. Now, the balance between what you include in the Constitution versus what you leave for Parliament to determine is an issue, right? It's a legitimate issue, and it was discussed at length in terms of this constitutional drafting before this was landed upon. It's an issue for all different groups involved in this constitutional amendment. So it's an issue for the government institutions, what they will be able to change, what they won't be able to change. It's an issue for the Australian people, but it's also a really, really live and important issue for First Nations people themselves. And I want to drill down on that because we don't necessarily hear that much about that. So for First Nations people, the issue of what's left to Parliament is acutely raised with respect to determining membership of those who serve on the voice, and also how it's going to interact with that executive government. And there is a genuine, a legitimate fear within Aboriginal and Torres Strait Islander communities and those that I've spoken to, that these may be unilaterally determined by a future government and passed by a future Parliament that fails to act in good faith, that fails to consult or listen to them in relation to these questions. But there is also concerns that if you constitutionalise membership of the voice, it would mean that the body is not able to be flexible. If you constitutionalise numbers or you constitutionalise qualifications, it's not able to be flexible. And for example, if the initial decisions about membership don't work, you couldn't be changed and adapted. All right, so there is these tensions pull against each other. Ultimately, where we've landed with respect to subsection 2 deals with the balance, shall we say, in 3 ways. First, it guarantees existence and primary functions. Okay, so that's 1 and 2, minimum guarantees. Second, it gives that power to determine detail to the Parliament, that's subsection 3, which allows for this flexibility. But third, and this is a really important third, the government has indicated that should the referendum be successful, it will enact legislation that accords with a set of design principles. Now, it has not unilaterally come up with these design principles. It is worked with the Referendum Working Group, which is a group of 41 Aboriginal and Torres Strait Islander leaders drawn from across the country, but it's also gone back into a lot of previous reports, for example, the Karma Langdon report, but also the Joint Select Committee on the Voice in 2018 and other reports around designing a model such as this. So the design principles have been agreed by government with the Referendum Working Group, and they relate to matters such as membership. They relate to matters such as how the voice is going to relate to the executive and Parliament, and things like accountability of the voice. Now, If the referendum is successful, legislation will have to be drafted, further consultation will have to be undertaken, but we know that it will have to meet those design principles. Very similar process to what was undertaken in post-apartheid South Africa. Okay, there was an interim constitution, the final constitution was drafted in accordance with design principles that were agreed. What we also know is once the voice is established, any further amendment to the voice under subsection 3, the voice will be able to speak on. Okay, again, it won't be able to dictate, it won't be able to veto, it won't be able to compel the government to listen or the parliament to listen, but it will be able to speak on. And you can bet that on things like the design of itself, it will have a very strong political force. Okay. So we see in these words of the amendment, it's complex. You have to capture history, historical reflection on the place and the treatment of First Nations. You have to capture the present with the objects of improving the current status quo and also the future. It has to be like this future narrative, nation building narrative. And it also reflects ultimately a pragmatic exercise. Drafting is a pragmatic exercise. It's a political exercise. There's different groups involved. And of course, we have to get this amendment through a referendum as well. So there's even more interest groups involved than usual. And then it's all performed in a highly technical arena of law. So there's all the lawyers who want to have a go as well. I'm just going to spend a little bit of time talking about the history of how this draft came to be as it currently is. I'm not going to do a true historical context because that would go back far too many decades and centuries. But I'm going to focus on relatively recent political history, which I think will contextualise this proposal and the amendment. I'm going to start 8 years ago, 2015. Really important starting point for understanding how we got to the voice. Constitutional recognition in 2015 had been 7 years in discussion in the public domain. 2007, John Howard had committed himself to constitutional recognition if he was re-elected. So it was his commitment that sparked the current debate about constitutional recognition. There had been subsequent pressure brought to bear on the Gillard government to establish an expert panel in 2010 to push this idea forward again. And you had the report of the expert panel in January 2012. It had proposed a package of reforms which included as its major focus, not the voice, but a racial non-discrimination clause, okay? If you'll remember, there was a hostile reaction from that 2012 process from day one. Then opposition leader Tony Abbott indicated that he would never support it. It was a one-clause Bill of Rights. And the Gillard government didn't openly reject the 2012 proposals, but it simply never responded to them, okay? So we had a number of years of conversation, funded government processes, but really no political capital being invested in actually pushing this forward, in actually doing something that would get us to the point of referendum, choice and amendment. There was a bipartisan commitment by this stage, so 2015, bipartisan commitment. Yes, we're all for constitutional recognition. What does it mean? Well, in fact, we don't know. Has anyone asked Aboriginal and Torres Strait Islander people whether they want it and what it means? The answer is, well, sort of, not really, not very well. So by July 2015, pivotal moment in understanding voice, we have 40 First Nations leaders taking the proactive stand in the Kirribilli Statement. They deliver it to the then Prime Minister, who then was Tony Abbott, and the opposition leader, because you have this bipartisan commitment, and says, we need a new process to move forward the discussion on constitutional recognition. That process needs to be focused on substantive constitutional reform, something that will make a practical difference in the lives of Aboriginal and Torres Strait Islander people, and it needs to be Indigenous-led. And they called for funding for a new process that would be a consultative process that was Indigenous designed, Indigenous-led. This was the first time, as Professor Megan Davis puts it, that the to be recognised were going to be given not just a say, but a decisive say in whether they wanted it and the form of it. Okay, So the Kirribilli Statement led to a $10 million commitment in funding, still bipartisan at that support at that point, and the creation of the Referendum Council. The Indigenous members of the Referendum Council formed the Indigenous Steering Group, particularly under the leadership of Professor Megan Davis and Auntie Pat Anderson, who became the co-chair after Pat Dodson moved into the Senate. And the Indigenous Steering Committee led a series of consultations in 2016 to design a deliberative process that would work in First Nations communities. So that's the Indigenous designed dimension. Then they conducted a trial dialogue to see whether it would work in 2016 before the full deliberative regional dialogues process was rolled out at the end of 2016 and into 2017. As you know, the dialogue process ultimately led to the National Convention at Uluru, which issued the Statement from the Heart to the Australian people. The call for change in the Uluru Statement from the Heart is vastly different from anything that had been seen before. But then again, the process was vastly different from anything that had been done before. So the call for change is for the First Nations voice, this idea of a political voice to government and parliament, and then further structural reform to be followed through Makarrata Commission providing national oversight for agreement making and truth telling. What is noticeably absent from the Uluru Statement is the 2012 reform of the Constitutional Racial Discrimination Clause. The records of the regional dialogues, which are now publicly available, provide a really important insight into why the shift from basically a rights-based clause, a rights against discrimination, to the idea of voice. An anti-discrimination clause takes the legal system as it finds it as the solution to the position of Aboriginal and Torres Strait Islander people today. It provides an after the event post hoc response to the potential for negatively, adversely discriminatory laws. That depends ultimately on court action being brought, and ultimately it depends on the judges agreeing that there has been a breach of the racial non-discrimination clause. It doesn't acknowledge foundational violence on the imposition of the legal system. It doesn't acknowledge the failures of those legal systems, that legal system that has so often been felt by Aboriginal and Torres Strait Islander people. The dialogues reveal a very acute awareness that Australian judges and the Australian legal method have not been reliably responsive to the position of Aboriginal and Torres Strait Islander people. So they're not going to invest all of their faith in the legal system. So rather than turning to the legal system, the proposal that comes out of the regional dialogues and the convention is the voice. It's a structural reform that talks about the place of Aboriginal and Torres Strait Islander people within the constitutional institutions of the state and what their relationship is going to be, not to the courts, but to the actual institutions of government, the executive and the parliament. This is a place that has previously been denied to First Nations people as a group of others that could be excluded at will. So this new constitutional position would recognise Aboriginal and Torres Strait Islander people as having a unique claim, which is about a unique place and ensuring that place with respect to political participation. The voice also presents an opportunity, as opposed to a rights-based clause, that recognises First Nations communities not simply as a historical matter, as a preambular statement they were here, right, but as ongoing, vibrant, evolving societies. That's why you keep speaking to them, right? So the voice is not intended, the voice is also intended to be selected in accordance with First Nations laws and customs, recognising the importance of that self-determination aspect. The voice, I think this is really important, it's often forgotten in what is often labelled deficit discourse. The voice and its advice to government is predicated, yes, on the importance of lived experience in forming policy decision-making and legislative change. So not just on the fact that First Nations have different life experience and are going to have solutions to the challenges and problems that they're facing within their communities, but also in recognition of the fact that there are different cultural norms and practices in a positive sense, in a vibrant sense, right, that should inform and will create better laws and policies. So there's this real positive dimension to the voice as well that I think we can often forget in some of these debates. So this constitutionally guaranteed voice is going to guarantee First Nations a place at the table when decisions are made about them, both by the government and by the Parliament. The Referendum Council, which was the overarching body that the Indigenous Steering Committee was working underneath, endorsed the proposals that came out of the Uluru Statement for a First Nations voice. And despite the rejection by the then Prime Minister, Malcolm Turnbull, of that recommendation, 5 years later, the proposal was kept alive. It was kept alive by people like Professor Megan Davis, and Arnie Pat Anderson, but also all of the people who were actually involved in the dialogues, and then all of the allies who read about the process and read about the reform. Of course, in May 2022, a really important turning point. The then Prime Minister-elect, Anthony Albanese, emphatically endorsed the statement and pledged to implement it in full in his acceptance speech. The process that we've gone from political endorsement to words that we're going to vote on the 14th of October may seem opaque to some people, and it may seem like the words have been sort of plucked out of the air on the 30th of July last year when the Prime Minister announced them at Gama. But in fact, these words had been the subject of ongoing and long-standing legal consideration. Professor Anne Toomey developed a set of words in 2015 from the University of Sydney, a leading constitutional lawyer. Professor Megan Davis led a team to refine those words based on the Uluru Dialogues in a 2018 submission, and continued to lead workshops with legal experts across the country from 2018 to the point where you got to in 2022, where the draft wording was released by the Prime Minister. The Prime Minister then convened the Referendum Working Group, was a group of Indigenous leaders to be assisted by a group of constitutional experts called the Constitutional Expert Group that included a former High Court judge as well as a number of constitutional academics. The Constitutional Expert Group advised the government. Ultimately, the wording that you see here was agreed between the Referendum Working Group, that is those 41 Aboriginal and Torres Strait Islander leaders, and the government. And particularly what we see in subsection 2 and the inclusion of the executive government, the scope of what the voice can speak on, that broad scope that I spoke about, and then the flexibility that Parliament has been given, that is part of a hard-fought agreement between the government and Aboriginal and Torres Strait Islander people. Okay, so I'm going to just sort of skip forward a little bit. We've got the referendum coming up in October, 15 years on from when I started this brief history, 2015, okay? We've had bipartisan support for constitutional recognition through that entire history. We finally have an actual proposal that has become concretised for the Australian people to vote on. It has survived countless predictions that it would never make it to a referendum. Those years after the issue of the Uluru Statement from May 2017, the number of times that Arnie Pat or Professor Megan Davis were told that this was not going to get there, and yet here we are on the eve of that referendum. Okay, I'm going to pause there because I want to give lots of time for questions and discussion. So that's a bit on the history and a bit on the wording. I'm really happy to answer any specific questions about the wording that you might have a niggle over or people are asking you questions about, and also happy to talk more about any of the process that I was involved in as well, of course. Thank you.
Yeah. Oh, you want
do you want us to go to here?
Yes, if I move this.
Yeah, that makes sense.
Thank you so much. I mean, I just think this is a referendum that has so much history. It has so much history over the course of decades and centuries, but it also just has this incredibly detailed, hardworking, effortful history over the last 5 years, 6 years, 10 years through these various processes. So thank you for your time in taking us through the amendment itself, the consideration and that went into debating it. I certainly have prompt questions, but we have limited time together in the last 20 minutes, and I would like to open the floor. And I want everyone here to feel like you can ask anything in this space. There are no questions off limits. And, you know, these are hard conversations, I think, sometimes to have outside with families and in our communities, but this is a space where we can have them.
We've had one come through on Zoom already. Right. Danny, did you want to ask your question, or do you want me to read it out?
I'm happy to ask. Thank you so much. That was really very helpful, really informative. It can be hard to have the conversations if you don't feel like you have a firm grasp on some of these facts. This is not really related to wording, but one of the key, I guess, points of contention for people is where will the funding come from for the voice or the money? And I don't know if that was a part of the discussions or if you can provide any guidance on how to respond to those people.
Yeah, absolutely. The question about funding is, I think it's part of a sort of a scare tactic, because people are worried about, particularly when we're in tight budgetary times, people are worried about spending more money on Indigenous affairs because there's already a sense that we're throwing away billions of dollars and we're not seeing good outcomes. So I think the question around funding the voice, I'm actually, Danny, going to take your question a step backwards, because I'm going to talk about why the voice is a practical reform, because that's related to funding. Right, so there is so much research and experience that if you engage with Aboriginal and Torres Strait Islander people and communities, you get better outcomes, particularly in relation to health and education and justice outcomes, which is where the predominance of Indigenous affairs funding is going to in Australia at the moment, largely without positive effect, right? So if we're just talking about the moment, the funding model, it is unsustainable. So we have an unsustainable funding model. So if we want to do scaremongering about funding, status quo is unsustainable. The establishment of the voice is going to cost money, just like the establishment of the Anti-Corruption Commission costs money, okay? It's not something that the government is unable to budget for. It's not something that that we have never done before. And so there is, yes, there'll be an initial outlay in terms of the design and the creation of the body. But because we know from this research and experience that once we start engaging with the voice on these practical issues, we're likely to see better outcomes, better value for money. I mean, the Auditor General has done a number of reports into funding Indigenous affairs, for example, the Indigenous Advancement Strategy. And we know that funding is not getting into communities, it's not making a difference, and the voice is going to change those outcomes. So it's really hard to say the voice is going to cost X amount. I could say, well, you know, the Parliamentary Budget Office has said the voice is going to cost X amount to establish, but then you would have to take into account what the future effects were of that voice. It's a complex process, just like any budgetary processes, and it will change. Like I imagine during times of economic downturn, the voice's budget will be restricted, just like every other institution's budgets are restricted, including the courts, right? And then they'll be increased. Like that's the way in which budgets operate. So you can't say once and for all how much it's going to cost. What you can say is that research and experience tells us once it's established, it will deliver better value for money because it will deliver better outcomes in an area which is already costing the government huge amounts of money.
Thanks very much. Thanks very much, Danny, for your question. And thanks, Prof. Anyone here in the room?
You sure?
Yes.
I'm hoping you can bring your religious legal mind to bear on a vexatious question I've gotten trying to advance the cause around the word may.
Mm-hmm.
In common vernacular, may has two slightly related but different meanings. One is permissive. You may have a Tim Tam. You may have one Tim Tam out of the packet. The other one relates to within the realms of possibility. If I buy a ticket every day, I may win the lottery. So the question I've gotten, well, which one? You know, around that ambiguity, is there some assurance? So can I assure a vexatious questioner that the sense of may here is permissive rather than the realm of possibility?
I can tell you that this question was debated at length by the Constitutional Expert Group, but was also the subject of significant discussion in those years before. You know how I said that this amendment just didn't come out of the air in 2022. So we held a number of workshops around the language of what's the best language to guarantee the function, right? So it can't be taken away. And so it's kind of like a right to make representations, if you will, although it's not the right in terms of sort of rights language that we usually use. So this specific question was put to the Constitutional Expert Group, and their view was that this language is a guarantee that the voice may, the word may is it can choose. It can choose whether to make representations. Now that Constitutional Expert Group advice has been released publicly on the NIAA website, and it's now found its way into the explanatory memorandum of the Constitutional Amendment. Okay, and the reason why that's important is that any future High Court that has to interpret this provision and it says, oh, there's a little bit of ambiguity here, I wonder what they actually meant. They go to the explanatory memorandum and they say, oh, that's what they meant by the words. Oh, it was informed by the Constitutional Expert Group. That's what they were advised it meant. And so it's pretty solid. Okay, yeah. It's not a vexatious question though, because it took a long time to get there. Yeah.
Can I ask a question which somewhat follows on from that? And I think you've half answered my question. Firstly, thank you so much for coming up and sharing all of your experience and expertise with us up here. My question is around that idea that the entire collateral that goes with the Constitution will influence future High Court changes. And you raised defence before, and that's the one that I keep thinking about, that AUKUS and all of those associated activities are going to be incredibly important to the people on whose traditional lands that's taking place.
Yes. So
does the fact that we've had politicians making statements like, no, not AUKUS, no, not this, or no, not that, does that come into the High Court's decision making in future, or is it just the explanatory memorandum?
It's a really good question. One of the reasons why Professor Megan Davis and I wrote the opinion piece where we said the Parliament won't be able to shut the voice up was because we wanted to counter some of the statements that had been made, often in the kind of rough and tumble of question time that might have come out of the Prime Minister's mouth or the Minister's mouth, and we're like, well, that's actually not, you look at the language, that's not what the provision is going to do, and it's important that that's set straight for the public record. Now, the reason we did that is more around the referendum. Like, we want people to be properly informed when they go to the referendum. But in terms of the interpretation, which is your question, the High Court limits itself to pretty official documentation, okay? So in the parliamentary debate that is directly relevant to the amendment, not question time. Question time is just like
free-for-all
performance, right? But the actual second reading speech, the explanatory memorandum, the parliamentary committee report on which, so the parliamentary committee, the majority said, look, you should pass this amendment without amendment, and all of the sort of findings it made about the interpretation, that will be relevant. That's an official piece of a document. And any legal advice that was given to government that informed its views will be included as well. So they're the kind of like the pool of documents that we know the High Court looks at. And the High Court is, it's pretty sophisticated. It's not going to say, just because there's this sort of political debate happening, if the language is there. And the thing about defence or climate change or Australia Day not falling within the scope of the voice, you look at that language and there's little ambiguity, and then you go to the explanatory memorandum. The explanatory memorandum is great on scope. It's really great about how broad it is, and then about the discretion of the voice within that scope. That's going to be the documents that the High Court looks at.
And really, if it's okay to follow on from that, really what the language does is saying it's up to the members of the voice to decide. And that makes a lot of sense in the context of a constitution that's intended to last centuries, where maybe there are issues that are not of priority or significance for Indigenous communities now, but that might be significant in 60 or 70 years' time. So I think that's a really, helpful and useful conversation to be having. Other questions? Prof. Jamie Fellows, head of our law school.
Yeah, thanks very much, Gabrielle. Great presentation. Several academics have actually come out. Greg Craven is one of them. He was on the expert advisory group, I understand. Questioning the language around the executive, and you spoke about that. What was their? I can't really quite understand or ascertain their main objection to that.
Okay, so the main objection is when you look at the language, the voice may make representations to the executive government. Okay, so it's the executive that they're worried about. There is a provision in the Migration Act which says that individuals may make representations to the minister, and the High Court has interpreted that particular statutory provision as saying the minister doesn't have to follow those recommendations but has to take them into account when making their decision, right? And so the argument is, well, this language in this constitutional provision may also imply a similar obligation on government to take into account the representations of the voice. Now, the Solicitor General has looked at this in depth in a very in-depth legal advice that's been provided to government and also released publicly. The analogy between the Migration Act provisions and the Constitution is deeply flawed because, of course, the Migration Act provision occurs in a statutory context in relation to a specific ministerial visa decision. This is an extremely broad obligation to the executive government at large, not in relation to a specific decision, etc. And so the Solicitor General's advice, which I should say, some former Chief Justice Robert French, former Justice Kenneth Hayne, the Law Council of Australia, they all agree with this advice, is that it is highly unlikely that the High Court would draw a similar inference. And in fact, when you couple subsection 2 with subsection 3, you actually come to an implication that it was intended that Parliament determines what's a mandatory and an irrelevant consideration, to use awful technical administrative law language. So that was the nub of the concern. And of course, some of you may say, and I wouldn't necessarily disagree with you, why would it be a bad thing that the executive has to take into account the voices' representations? And of course, the answer is, well, that's the hope. But the kind of the compromise here is that it will be for Parliament to decide what decisions are so important that the executive must take into account the voices' representations, and what are decisions where if the voice speaks, the government has obviously lots of people speaking to it about those decisions, and it kind of comes into that mix. So that's the compromise that's been landed on there. Of course, we should also add that Greg Craven, whilst he was a critic of subsection 2, is now a full-blown supporter of this constitutional provision and advocating for a yes
Who
vote.
was quoted in no campaign?
Yes.
Misquoted.
Well, look, those quoted in the no campaign are in good company.
Thanks so much, Prof. If I may use my chair's prerogative, I'm going to ask the final question. There is, across the country, we have conversations about civics education. We've looked at the familiarity that most Australians have with the Constitution, whether we have a Constitution, what's in the Australian Constitution, and we know that there is a limit to the level of public understanding. What is your take-home or top-level message to friends and family and members of our community who might not know really what the Constitution is or what it involves, about what's being asked here? And I think it's safe in this room to say why you think it's a good thing.
Yeah, sure. When I try to explain it, I try to sort of pick up some of the points that I was making before about the usual constitutional practice, that we're being asked whether we want to enshrine a stable and independent representative body for Aboriginal and Torres Strait Islander people that has a minimum function of providing advice, okay? And then the full detail, any other functions it might perform in the future, gets to be determined by Parliament through normal parliamentary processes, can be changed by Parliament. And this is exactly like when we established our Parliament, right? The existence and the core function of our Parliament is in the Constitution, and things like membership and other things that the Parliament does is determined by legislation. So there's nothing radical about what the Australian people are being asked to do here in terms of what we're being asked to constitutionally enshrine and what's being left. I also really like to emphasise sort of point that I made peripherally about the Interstate Commission, which is this institution has been developed in congruence with the existing institutions, right? It's supposed to help government. It's supposed to help Parliament when they do their jobs, right? It's not going to stop them. It's not going to be able to stop them, but it's going to be able to inform them. And in that way, it's about making the way the system currently work better. It's about enhancing. It's about improving. And yes, that's for Aboriginal and Torres Strait Islander people as a constituency, but ultimately we all have not just the budgetary vested interest, which is a little bit kind of base, but it's there as well, but we all have an interest in seeing better outcomes for Aboriginal and Torres Strait Islander people in Australia. So this idea of it's not just nothing to be afraid of, and that it doesn't stop the parliamentary government doing its role, but it's something that actually gives us a possibility of having them do it better.
Thank you very much. Thank you very much for your time. Thank you very much for travelling. Thank you to everyone in the room. I think increasingly in the different spaces that we're in, we all observe that people who come into these spaces are very supportive. And if that's the case of you, I guess one of the things I'm trying to encourage people to do right now is that if you support this proposal over the next few weeks, it's time to get loud about it. It's time to share that you support the voice with friends and family members. No one's asking you to have fights with people that you love. You know, I'm not doing that either. But to share with people that you are voting yes, to make it feel safer and okay for them to share their support, and to be available to people around you with information or answers to their questions, or being willing to listen to their concerns. We know that voters' most trusted source of information is friends and family. And we know that friends and family are not where they're getting most of their information on this at the moment. So everything counts. And thank you for being here. Thank you, Professor Appleby, for all of your expertise and your insight and experience and your years of dedication to supporting the work of the dialogues and getting us to this point.